It's Nick Rollason here from Kingsley Napley. Welcome to the webinar, Managing Your Migrant Workforce in the COVID-19 Crisis. We thought it would be very useful at this fairly early stage in the shutdown to talk to our clients about what's going on out there with the Home Office and to look at some of the key issues that we're seeing, problems that we're seeing, questions that we're being asked by our clients and by individuals as well. So people, contacting us pretty regularly with lots of quite complicated questions about them or their families being stuck outside the UK, then wanting to extend their visas in the UK, and at the same time having high-level discussions with the Home Office about how they're going to manage this. The Home Office have issued some guidance. We've shared that with you through our alerts. Hopefully you've seen those. You can look at our website if you haven't seen them yet, which are updating you about what the Home Office is proposing to do. Unfortunately, at this stage, the Home Office guidance is very, very broad. It simply gives some reassurance to people who are already here and who are seeking to come here and to employers, but it doesn't do much more than that. And it simply states in press releases and documents, there's been no change in the immigration rules to deal with this, and unfortunately, we are sort of slightly in the dark as to what is going on with the guidance at the moment. So I'm going to just move on to the agenda for today. Which will hopefully come up in your screen any second. We're going to look mainly at some logistical issues about applying for visas inside and outside the UK, those who are coming to the UK. We're going to look at when employers are looking to hire new people, bringing in intercompany transfers, or people who are changing employers in the UK. We're going to look at right to work checks, working from home. We're going to look at the big question which we're being asked a lot about, and our employment team is being asked as well. And that is about furloughing Tier 2 migrants and reducing hours and salaries in the current crisis, and the job retention scheme and how that works. And then finally, we're going to look at absences and minimum salaries for ILR, which is something that I think a lot of employers are not thinking about necessarily at the moment. So if we look firstly at the logistics where we are at the moment, as we know, if you're outside the UK, you can file an online visa application. You can issue a certificate of sponsorship for an individual to do that. But unfortunately, all VFS and TLS visa application centres are currently closed until further notice. That was announced finally on the 1st of April. They were partial closed down for that. So if you're outside the UK wanting to come in, it's not possible for you to actually get a visa at the moment. We are keeping it under review. We've got close connections with VFS and TLS. And as soon as any centres start to reopen, we will let our clients know and update them through an alert. The important thing to say is this: if you have employees who have been travelling who currently have UK visas, so Tier 2 visas in particular, who are outside the UK, and those visas are coming to an end, you should seriously think about not just letting them lapse, because there's all sorts of implications for that, both in terms of cooling off for Tier 2. So you might find that you're then stuck outside the UK, can't come back in with a new visa for 12 months, although we hope the Home Office will lift those restrictions in the current crisis. But also it's important for those people who are on track to get indefinite leave to remain and want to show 5 years of continuous residence. So please, if you do have an employee stuck outside the UK on a Tier 2 visa, don't let it lapse. Do something. That might just be filing an online application and paying the fee and then waiting it out, but it's important not to just leave it. If you're inside the UK and you're looking to extend your visa as a Tier 2 migrant and any other visa category, unfortunately at the moment all UK VCAs are currently closed. There are also no provisions for doing life in the UK or English language tests for those who need them for ILR, for example, or for some extension applications. But we are recommending to everybody that they make online applications in time before their visas expire. And the Home Office have said, although not in writing, they've said it on a conference call with ILPA, that applications will be put on hold until people have had a chance to take the tests and to do their biometrics. So it's important to remember that you must make applications for everybody in the normal way, and then they will simply have to wait until these biometric centres are open again. So just in terms of coming to the UK, we have lots of people who have been issued with 30-day visas and have them in their passports, but are not able to travel because there's no flights, because they're self-isolating, or because the guidance is they shouldn't travel except for emergencies. So normally, if that 30-day visa expires, you have to apply for a replacement vignette. And please note, you don't have to get a whole new visa and issue a new COS. It's just a replacement 30-day visa. But unfortunately, there's no visa centres open. So some of those people will have had BRPs sent to us, to the representatives. We might be holding those at the moment, waiting for them to arrive to deliver them to them. And some of them may have gone to post offices, which was the other way that the delivery of BRPs is done. We are trying to persuade the Home Office to put in mechanisms for those who can't travel, for particularly visa nationals who have 30 days visas that have expired, to get their BRPs to them so they could maybe able to travel and come in and be able to start work, hopefully. That's fairly not that many cases of this kind, but we are seeking further guidance from the UKVI, and we've been told that we should be getting guidance on these questions shortly. So again, what about bringing in new hires, ICTs into the UK? As we said, everything is pretty much on hold. You can do all the things you want to do. You can assign the COS, you can apply for the visa, but you can't complete the visa applications. And also, if you're looking to hire somebody who is in the UK, where you've been potentially advertising already, looking to change employment, unfortunately, because the biometric centres aren't open, you won't be able to complete that application. And the real problem is that you cannot start them working for you until they have their new BRP, which can only be done once they've done biometrics. So basically, all hiring of tier 2 is going to be on hold at the moment, and you're going to have to sit it out. Obviously, if people want to change employers, they're going to have to stay on with their other employers. There are also issues about people who've given notice and that they were expecting to move across, and they're now not able to do that because they can't get an appointment. So if you have any of those issues, let us know. We're happy to help and advise on the best way forward, and we're again seeking the Home Office's guidance on that. The good news about one of the bits of good news is that the Home Office have loosened up the switching rules. Since 27th of February, people who are on Tier 2 ICTs were able to switch to Tier 2 Generals. And you know, that's generally only allowed for high earners, but that can be done in the UK. And since the 27th of March, you can switch from any visa category where your visa is expiring up until the 31st of May. You can switch into any category. So even if you're in the UK as a visitor and your visa is running out before or on the 31st of May, you can switch into any long-term visa category. So for example, if you arrived in the UK in November, you ended up staying too long because you wanted to hang out and do stuff, and your visa is expiring sometime in May, then you will be able to switch. There are not going to be that many cases. This is only really there for sort of emergencies. And please also bear in mind that you have to make a full application to the Home Office, and that application won't be able to be completed until, as we've said, the biometric centres are open. The other thing there is provision for emergency extensions. So people who are here in the UK, can't leave, and whose visas are running out will have their visas extended, but they have to send an email to the Home Office to get that done. And again, only where their visas are running out until the 31st of May. Any other person cannot apply. Say if their visa is running out in June, July, August, they can't benefit from these automatic provisions. So they will have to wait and see whether that 31st of May deadline gets extended. And as you may have seen, the good news is that NHS frontline staff are going to get automatic extensions for a year if their visas are expiring before 1st October this year. So the big concern for us was to do with people starting work. So people arriving in the UK where firms have sent everybody home to work from home, the office is closed, HR not in the office, and everything needs to be done remotely. So the first thing to say that you can carry out remote right to work checks. The Home Office have issued guidance on this. Again, look at our website and our FAQs, which I'll give you the link for at the end. And you can do these remote right to work checks by taking a copy of the passport photo page and the BRP to be emailed to you by the employee, then set up a Zoom, Skype, or whatever video call to physically see the employee on video and for them to show you the documents, so the passport and the BRP on video. Then you make a note that you've done an adjusted right to work check and the date that's done on. So you'd have to, a specific wording that you have to use just about carried out an adjusted right to work check and date it. And then once the COVID-19 exceptional measures come to an end, we don't know when that will be, you have to carry out a follow-up check of the physical documents within 8 weeks of that period. So it's important that you make a note in your systems that you will need to carry out the follow-up check so you do have the protection that you need from right to work checks, excuse me. The alternative is that you can do an online right to work check. That involves 2 stages. One is that the employee gets a right to work share code by going onto a particular website. We've sent in our FAQs the link to that, so you can look on the FAQs, and then they will share the code with you, and with that and their date of birth, you can do your online right to work check, which is a one-off. You don't need to do follow-up checks with that. So just looking at some of the issues we're seeing at the moment and queries we're having from employers. Working from home, we got clarification directly from the Home Office before this was announced that there was no need to report a change in location if any of your staff are working from home. The second issue is to do with salary reduction. So a lot of people are thinking about furloughing employees, or they're thinking about just a salary reduction. The important thing to remember on salary reductions is that if you do reduce salaries, the person still needs to be paid the minimum salary for the particular occupation. So as you know, for experienced workers, it's 30,000. It's slightly less for some more junior employees or people switching from student, etc. But the key thing is that the salary has to be at the minimum level for that occupation. And you have to report the change in the salary through the SMS. If you reduce salary and hours, so you're reducing the hours, you can do that, but the salary must still remain above the overall minimum for the occupation, and you still have to report that. Also, remember that with unpaid leave, normally there's a restriction on migrants taking more than 4 weeks unpaid leave. Normally you'd have to see sponsorship once you go over the 4 weeks. Now, according to Home Office guidance, they can take more than 4 weeks and be completely unpaid, and you can continue sponsorship and you don't need to report it. So it's a bit odd that you need to report reductions, but you don't need to report the fact that they're receiving 0 salary. And we will probably get some further clarification on these two. The big issue at the moment is furloughing. The key thing to remember is all Tier 2 migrants can benefit from the job retention scheme that was announced by Rishi Sunak. The key thing is that they must have been on the UK payroll on the 28th of February in order to benefit. And you have to be aware that some of your ICT holders who are in the UK may not be on UK payrolls. They may be still on overseas payrolls, even though they might be registered to pay some national insurance here. If there's no treaty on national insurance and social security contributions, that may not count as payroll because they won't be on PAYE in the UK. So you need to look very carefully at were they on PAYE on the 28th of February and onwards. If not, then they will not be able to benefit, and you will not be able to furlough them and benefit from the furlough scheme. So the question we're being asked is, can the salary level drop below the overall minimum? So for example, if you have a senior manager, you know, their minimum salary on the SOC codes is 38,000. Can it drop below that level? Well, remember that we said non-furloughed migrants can take unpaid leave, so they can be paid 0 for more than 4 weeks. it would make sense that furloughed employees could be paid less than the overall minimum, because if you have somebody who's just on unpaid leave getting zero, they're fine, they can remain employed and sponsored. But then you have somebody who's furloughed, and if the Home Office said that they would have a problem, then we don't think that's right. So we are seeking clarity, urgent clarity from the Home Office. But at the moment, the position is you can furlough them. The only concern is if their furloughed salary, so the 80% that they're receiving of their overall salary, takes them below the SOC code minimum. And I think that's an area that we need to look at. Finally, the key issue that you need to think about is the indefinite leave to remain provisions. We've had lots of issues around absences from the UK, so people who are stuck outside the UK and can't come back in, either because there's no flights, or because they're self-isolating, or because their current lockdowns don't allow them to leave and travel. The position at the moment is that the Home Office do have discretion. There's specific discretion on the 180 days around international disasters and people working in emergency rescue situations, but the Home Office can consider any serious or compelling reasons. We expect that they will accept all COVID-19 related reasons for not being able to return to the UK as being serious or compelling. We also expect, most likely, that the guidance on the exercise of discretion for the 180 days maximum outside the UK will also be amended to include COVID-19 as a specific reason why people couldn't travel back to the UK. The key thing we would say on absences is that you must keep some evidence of why people couldn't come back. So if there's flight cancellations, keep those. If they have medical problems or have been told to self-isolate, they should keep that. If their local health authorities are telling them to self-isolate in certain circumstances, they should keep that guidance. We're expecting the Home Office will be relatively relaxed about this, because it's going to be quite difficult for people to be able to provide lots of evidence to say why they couldn't come back. The other final thing on indefinite leave to remain is to do with the minimum salaries. As you know, at the moment, if somebody wants to get indefinite leave to remain, they have to be paid £35,800 per year, and you have to provide specified documents with the ILR application, including payslips and confirmation from the employer that is the case. We are hoping that the Home Office will waive this requirement where somebody is furloughed and is coming up for ILR. So in that case, they would only be paid maximum £30,000 under the government scheme. And we do expect that too will be dealt with through some further guidance. Having said that, if you do have somebody coming up for ILR now, we recommend that if you can, and if they're a key member of staff, you want to retain them, you should put their salary up to 35,800 until we get clarity from the Home Office. So just remember that, and that can be just for that month when they're actually applying. So just bear that in mind, but it's important that they have a payslip to show that they're on the equivalent of 35,800 until we get clarity. So to finish, we've got questions. I should just say before I go to the questions, we've got 2 FAQs on our website. There's a link to them on the slides, but you can go to our Kingsley and Aptley website, and you've got immigration FAQs from our immigration team. My colleague Kim Vowden has been very active on this with our professional support lawyer Tim Richards, and also we have employment FAQs which cover the furlough mainly, and what that means for employers. So please do have a look at that. If there's questions that are not answered by that, we can clarify those offline. So I'm just going to have a look and see if there's any questions on the Q&A, but do feel free to send through your questions on the Q&A tab on the Zoom screen. Yeah, so I've been asked one question so far. For those who are issued with a Tier 2 general vignettes and who are unable to travel to the UK, what's the position on delaying the start date for more than 28 days where they're unable to travel to the UK on their vignette? So at the moment, there is no specific guidance on delaying the 28 days, other than the guidance which says that people shouldn't be prejudiced by the COVID-19 crisis. So what we're saying is make a sponsor note to say the person's been unable to travel because of COVID-19 issues. And the problem is they won't be able to come in, we're thinking, for a lot more than 28 days at the moment. So do put a sponsor note on. The Home Office will no doubt issue further guidance for people who've been issued with visas and who haven't been able to come in. We're hoping that's one of the main things that we work with. We're also expecting that if a Tier 2 vignette lapses abroad, that cooling off will not apply, and the migrant has not entered the UK, and that's right, because they haven't actually activated the visa, they haven't arrived and started work. So on that basis, generally, if you can show they haven't come, then no cooling off would apply. And we're expecting cooling off not to apply generally for people who are caught out by the crisis. Again, the Home Office have to give us clearer guidance on this, and we're expecting that. We're hoping relatively soon, but I can't promise. I've just been told by my colleague Gillian Brownlee that the Home Office have just released, while we've been talking, a policy on furlough. So what we're going to do is, I'm not going to be able to deal with that right now. We will do an alert to all of you. If you're not signed up for our alerts, please do. You can sign up on the website, or you can email me or my colleagues at the King's Enacting team, and we will provide you with a summary of the new Home Office policy on furloughs. We also have a question about a high earner who wants to take a temporary salary reduction for 1 month that will take him under the high earner threshold for 1 month only. Will we need to report this, and is this an issue? So if this is related to COVID-19 and is not some other commercial reason for doing this, like a tax reason or something, then it's possible that you can do this, but you must report it on the SMS. Yeah, and you would need to show why it's related to the COVID-19 crisis and why it's being done. So again, it's important to relate any of these salary reductions back to the COVID-19 crisis. Again, if you look on our FAQs, you will see on that it says that if you are a high earner who's dropping below the high earner salary threshold, then there may be an issue with being sponsored under that. But what I would suggest is that we can revert back to that question and send, I think it's Helen who sent that question. We have another question. So with a Tier 2 renewal coming up, will any grace period be permitted on the application date? We are still recommending to everybody that they make applications in time, simply because we want to make sure that those applications are in the system, any appeal rights are preserved, and that the person doesn't end up as an overstayer during the period of the application. That can have all sorts of impacts on indefinite leave to remain. It can have impacts on particularly nationality if there's a long period of overstay. So please, if you have a Tier 2 renewal coming up, get the online application filed, pay the fee, and then wait it out until you get the opportunity to book an appointment. The other thing you should know is that at the moment there's a time limit on booking an appointment of 45 days. We're expecting that to be extended because there's likely to be a huge pent-up demand for appointments. So if you can't book an appointment now, you'll be able to book one beyond the 45 days at some stage. But do make those applications, because there are all sorts of complications that arise from failing to make an in-time application. Then there is information the Home Office have shared with ILPA has not been made available to the general public. Why? I think the issue is this, is that ILPA had a phone call with the Home Office, and the Home Office was saying, their message was, look, don't worry. Generally, anybody who's prejudiced by the COVID-19 crisis in their immigration status will not be prejudiced, and we will not hold any periods of overstay against them. Going back to the previous answer about the Tier 2 renewal and grace periods, I still think that this is not a time to sort of be thinking, oh, let's just not do anything and not make any applications. And I also recognize that some firms may be under financial constraints in terms of paying things like application fees. But we do recommend still that it's important that those applications are made in time, if possible. And the question as to why ILPA's not been showing those is that the Home Office have said, please hold on for a second, give us the opportunity to give more specific guidance, and we will then make that public and share it with everybody. They're being quite tight-lipped at the moment about things. And even the high-level contacts that we have are saying, look, you know, we'd love to give you an answer, but we need to have a consistent messaging for everybody. They did give us an answer on the working from home policy before it was released publicly, but they've decided basically to rein that in and only make public announcements rather than giving advance notice of stuff through ILPA. So ILPA has been told sort of in broad terms what's happening, but not that much. We have got a question about a Canadian staff living in Africa with a British partner. Due to the virus scares, they've flown back to the UK. They can apply under the Tier 5 Youth Mobility Scheme, but they can't make the application. So in relation to that question is, if you're eligible if you're eligible to switch to the UK in the UK from your visitor status to Tier 5, you can only do that if your visitor status is running out before or on the 31st of May. So at the moment, there's nothing that says that anybody can switch. They can only switch if their visa is running out. And obviously, if somebody's arrived in the last month or so, then they're not going to be able to do that because they will automatically be given 6 months on arrival. So unfortunately, switching is not going to be allowed. They'll just have to wait in the UK on their visitor status and wait until the Home Office give further guidance to say that everybody can switch, or extend the period for switching for people whose visas are running out, say in 6 months' time. So I think we're sort of reaching the end. We've been online for half an hour. I hope that that's been helpful. I can't see any further questions. If you do have any further questions, you can put them on the Q&A now, and we'll pick them up and answer them when we send out the recording of the Zoom webinar. So a full recording of the webinar is going to be sent out to all participants. We'll hopefully get that out to you probably later today. And what we'll also do is we'll be looking to do an alert on the Home Office's guidance on the furlough scheme fairly shortly. There is one other question that I have. Yeah, when you say make an in-time application, is it okay to extend using the extension provisions to 31st of May and then apply? Yes, so if your visa is running out before the 31st of May, you can ask for an automatic extension through the email. We are seeing the Home Office sending out emails to people saying you've been granted an automatic extension to 31st of May. Yes, you can do that. And then if the Home Office haven't extended that period at the 31st of May, you can then make an application to the Home Office. But that will obviously be in limited circumstances of people whose visas are running out by the 31st of May. We expect that period will be extended probably for a further period because we're not expecting necessarily this all to be finished by the 31st of May. But the problem you have to expect is that the Home Office don't tend to make these announcements about extending these periods until fairly shortly beforehand. So on the 31st of March, with regard to the last scheme for extending visas automatically, they only made the announcement on the 27th of March, so a few days before, which didn't really give people much opportunity to plan and file an application if they needed to. Next question from Thomas. Will the requirements to have no more than 90 days absence for citizenship be relaxed as with those for ILR. So at the moment, the Home Office guidance on absences for British citizenship when you're in your last year before you apply for citizenship when you have ILR are that you can spend no more than 90 days outside the UK. It's actually, there's discretion to take that up to 100 days. And there's also discretion for work-related travel if you're employed in the UK. However, if you go over that and it's not work-related and you're stuck outside the UK, we expect the Home Office to exercise discretion on the basis of compelling, compassionate reasons, which is a general catch-all for discretion to be exercised. So yes, we're expecting anybody caught by the COVID-19 crisis and stuck outside the UK for longer than is allowed for citizenship to be able to get discretion exercised. We are saying to people though, please keep evidence that your flight was cancelled, keep evidence of any medical condition that you have, keep evidence of local guidance in the country you're in, showing that you can't travel and you can't go out except for emergency reasons. Somebody's asked for a bit more information on switching visa categories in the UK. So just so you know, the switching categories, which I've sort of mentioned a couple of times, it's only possible to switch categories if your visa is running out by the 31st of March. So for example, if you entered as a visitor in, say, October and you're still here and you can't leave, you can extend your visa until the 31st of May under the automatic extension provisions. Or if, because it will be running out before the 6 months that you're given automatically when you enter would be running out before the 31st of May, then you can apply to switch to any visa category. So that could be a spouse visa, it could be a tier 2 visa, it could be any type of visa. As long as you meet the main criteria for that visa. So again, if you're switching to a spouse visa, you need to meet the income thresholds. You need to, show you've got accommodation and show that you've in a genuine relationship and so on. But it only applies to people whose visas are running out by the 31st. Anybody else who's in the UK who'd like to stay here, so if they arrived as a visitor, say in March, they're US citizen, for example, they arrive going through the E-gates, they will have been given 6 months on arrival. So the 6 months will go beyond the 31st of May and they will not be able to switch. There'll be no switching for them. So I think it's very important to just not to say there is a general switching allowed. You have to look and see when the person's visa runs out. And obviously most visitors won't have been in the UK for more than 6 months or anywhere near 6 months because that's going back to a period well before the crisis. So the question I've got is, can't the Home Office reuse old biometric data, i.e., can they just reissue a visa without you having to do a biometric appointment? We think they could, but the systems are unfortunately geared on having to refile biometric data every time that you want to get a new, say, 30-day vignette or new status. We don't know whether the Home Office could do this and reuse biometric data and just send out the visas. The problem is, logistically, you'd need to have something in your passport, and the Home Office are not issuing e-visas or e-vignettes at the moment. So they might start doing that, which would be great, because then you could travel based on a travel authorization, which you get by email. But at the moment, you have to have a vignette in your passport in order to enter, say, under tier 2. What we have asked the Home Office and what we're hoping that they will accept is that for certain non-visa nationals, so for example, if you're a US citizen, you have a 30-day vignette which has expired, but you can still travel to the UK without a visa. What we're saying is that those people should be able to travel in, collect their BRPs and start work, even though the 30-day vignettes run out. So that solves a problem for non-visa nationals. We're hoping if they accept that they can do that, subject to them getting flights, but it won't solve the problem for non-visa nationals who won't be able to board a flight without having the vignette in their passport. So the visa nationals are going to be in a real difficult situation. And there, the Home Office could do things like send an email, but they're obviously concerned about fraud and so on, and misuse of these documents. But to be honest, and also the airlines are going to have to work out what's allowed, what's not allowed, and that's going to be a real problem. So at the moment, biometric data can't be reused, but it may be in the future. Then we've got a question about the restrictions on early entry on a tier 2 vignette be relaxed due to travel restrictions. So yes, some employees have entered early as they would considered travel restrictions. Yeah, an online right to work showing they're eligible to work. Again, the Home Office are saying that because of this crisis, generally nobody's going to be penalised, both employers and employees, for any issues around compliance to do with employees. Now, they've issued right to work checks. You should still try and follow the right to work checks where you can, but obviously if they've entered early, the BRPs, to be honest, the BRPs, if they're here and they have BRPs, they should show the right to work check from the date of the issue of the visa, so that will be in force, so they will be able to work. And when they're not expecting people to have to leave and come back in, because that's going to be very challenging. Again, it's one of those questions that the Home Office will have to deal with, but generally our view is that if people have entered early, there's no way you should be sending them out of the country to re-enter within the 30 days. And as long as the BRP is there and they have the BRP and they can collect it and show it to you, then you've done your right to work checks, you've done the checks, they're good to go, you should be able to start. So I think there's one more question. Which is the clarification on the biometric data. Biometric data is only normally kept for 40 days, and that's under data protection rules, I think, and it's destroyed, which is the reason why it needs to be taken again. The issue is around the 30 days, is if you're trying to get in and trying to get your biometric, you might be within the 40 days, and the Home Office could reuse the data, but unfortunately the way their IT systems are set up, they can't reuse biometric data generally unless there's a major change to the system. So we're not expecting that to change, but we'll watch this space. I've got one other question which I'm going to take, and then we're going to push all the questions out to you, the answers to any additional questions out to you on our through an email, which we'll send out the recording on. If an individual switches to tier 2 in country, are they able to start work under the tier 2 general if they're unable to get a biometric appointment in country? Would they be extended on the tier 5 for the duration of time before the tier 2 is issued? So the position is this: if you make an in-country application in the UK to switch status, and that's done before the visa expires, then your current visa, if you're on, say, tier 5, is automatically extended until a decision is made on the tier 2 switch. Yeah. So yes, you can continue working because your visa is automatically extended under section 3C, and that stays in force until a decision is made. If the person can't take biometrics for months and months because there's no appointments available and no centres open, they will remain on their tier 5. They'll be good to continue being employed. And then when the Home Office do finally open the centres, they can switch to tier 2. And remember that the switching rules, again, only applied if your tier 5 visa in that specific case was running out before or on the 31st of May. And then they will then see you qualify to switch, and then they will switch you. So I think we're going to end the webinar there. It's now 10:42. Thank you very much to all of you for taking part. I do hope this was helpful. Please do look at our FAQs on our website, both the immigration ones, the employment ones. They are being updated on pretty much on a daily basis. And in fact, on yesterday, we were updating them on an hourly basis. And any new questions that you have, we're going to try and reflect those in the FAQs where they will have general application. So hopefully there'll be a useful repository for everybody to be able to go back and look at particular questions and they will be live and updated regularly. But thank you very much, everybody, for attending. I hope you all stay safe and well, and that you manage to get out and do some exercise, and that lockdown is not too painful for you. And I hope that next time I will see you, hopefully will be over a breakfast coffee in our offices when we're doing our next live breakfast briefing. Good to have you all here, and thanks again. Bye-bye.